Hello, everybody. My name is Professor Christina Nolan, and I teach within the Department of Legal Studies. This video is originally created for the Introduction to Torts class, and we are focusing on intentional torts, which we cover in Unit 2 of the course. However, if you're not taking the course and you're just interested in intentional torts, I almost said intentional courts of intentional torts, then you may want to watch this video just for the sake of interest. And I have a little Google Gemini image in the presentation, and it looks like this cat is committing the intentional tort of false imprisonment. I don't think that little bird needs to be imprisoned. I don't think he wants to be imprisoned. So that cat better watch out because he may be sued by that little bird. We're going to be talking about intentional torts in general. I'm going to give you some background information. In a nutshell, these are civil wrongs that happen because somebody meant to do the act that caused harm. They were intending to do what they did. And so this is the key difference between intentional torts and negligence, which you will also learn about when you study torts. Negligence is just pure carelessness, and intentional torts involve purposeful conduct. So again, it's based on the defendant's purposeful act, not just a failure to use reasonable care. Now, that doesn't mean that somebody needs to intend the exact injury. They don't need to wake up and say, today I plan on committing a tort. It just means that they intended the action that led to the harm. So again, very broadly defined, reflects the tortfeasor's state of mind and occurs simultaneously with the misconduct. You don't need to have malice either. This cat here is taking matters into his own hands, and he is committing an intentional tort against that poor dog, to the horror of that hamster and the little goldfish. Just to clarify too, so you're gonna think, oh wow, that tort sounds like a crime. Like, can't they be charged for that? Don't maybe they need to go to jail for that? And that's true. The behavior that causes or that the tort arises from can also be a criminal act. Tort law is part of civil law. Criminal law it is its own thing. There are differences in how we approach these in law. Obviously, to the slide, obviously in a tort case, a civil tort case, you're suing the tortfeasor for money. It's the plaintiff versus the defendant. The plaintiff is the victim, or maybe the family of the victim if the victim actually passed away. But in a crime, it is the government versus the person who is accused of committing the crime. So they're handled in different courts. You could have an event happen and have a tort and a crime arise out of it. So we can do both. The state can prosecute the crime. The victim can civilly sue the tortfeasor for money. And oftentimes they do. So here's just a list of some examples of intentional torts. There's a long list. There's a lot more than this. Here's some of the main ones. So let us take a look at the tort of assault. And you know what? Some people, I am some people, even though I am a lawyer, we occasionally mix up the torts of assault and battery. And so in tort law, we're going to look at assault first. So this is about reasonable fear or apprehension of imminent harmful or offensive contact. So that's the fear, basically. And actual physical contact is not necessary for there to be the tort of assault. So if I raise my fist like I'm about to punch you, and you're not too worried when you see my fist, but let's just say you reasonably believe I'm about to hit you. And you know what? Guess what? Even if you don't think it's gonna hurt, you could still sue me for tort or for the tort of assault. If I'm about to punch you and you reasonably believe that I'm going to hit you, that's assault, even if I miss, even if I never make contact. Um, so it's that reasonable apprehension of an imminent harmful or offensive contact. I need to memorize that because, like I said, we often confuse these two terms. Here are the elements of assault. Again, in order to prove this intentional tort happened, you've got to prove all of the elements. This is where the lawyer, the paralegal, develop the evidence to support these elements of this tort. If you can't prove all of them, you're probably not going to successfully assert that tort in court. Apprehension. So this is where a person reasonably fears for their physical safety in anticipation of being struck by an unconsented, harmful, or dissatisfied contact. So, we always use that mosh pit example. If you put yourself there in the mosh pit, does that mean you're consenting to possible contact? I mean, I don't know. What do you think? But like the mosh pit of a concert, you're putting yourself there. You know what the mosh pit's all about. It would be different if you were forced to go there. But if you put yourself there, maybe that's implied consent. Okay, so the next slide. Here's an example of assault apprehension. All right, so let us move on. Well, here's another little example. Jane's facing away from John. John points a gun at Jane. Is this an assault? This is a tricky one. That is an AI generated picture, thanks to Gemini. It's not exactly the best depiction of this example, but it was my best try. So we're talking about assault. Does Jane know that the gun is being pointed at her? Let's say she has no idea because she's facing away. I don't know if this would be an assault. Probably not, unless there's some other facts. Battery. So now we're looking at battery. I forgot about this picture. Remember when Pink and Justin Bieber? I think people laughed about it at the time, but later on, it's been analyzed. And so 3 elements of battery: intent to touch the person, harmful or offensive contact, non-consensual. I mean, again, I think this was at the Grammys many years ago because Justin Bieber's now, I don't want to say an adult, but a grown man. And I believe he was under 18 in this picture, although I'm not 100% sure. But if you look at that, kind of like the 3 elements do kind of jump out at you there. We're assuming it's non-consensual because of his face. So what if so battery is the actual harmful or offensive contact. We had the assault, which was the apprehension of, and the battery is the actual contact. So throwing a drink on someone during an argument, that is battery. Shoving someone in anger, battery. The contact doesn't have to cause serious injury. It just has to be harmful or offensive under the reasonable person standard. So you could say the Justin Bieber situation, well, he's not injured. He's fine, But again, we're looking at the definition of the battery, what you need to prove. Also, notice the word okay, that was about assault. So forget it. So we're just talking about, now we're focusing on batteries. I'm not going to mention that about assault. And again, battery is one of those that can also be a crime. In many cases, you will have an assault and a battery. So if you were suing someone in tort, you might bring those, count 1 assault, count 2 battery. No touch is required in an assault. A touch is required in battery. There's a battery example. And I'm looking at the picture. That is not John and Jane. That is obviously this. Let's just say they're two different examples on the slide. Let's move on to false imprisonment, which is what that cat was doing at the first on our cover slide to that precious little bluebird. This occurs when somebody intentionally restrains another person without lawful authority. Okay, all of those are important. So think practically. Let's think of this little example here. I mean, there are some false imprisonment situations often. We've even seen people say this if, like, loss prevention in a store suspects somebody of stealing, you often see a lot of lawsuits arising from that if they can prove false imprisonment. So here's a scenario. A college student is at a retail store. I won't name it because this is a fake example. An employee thinks the student may have slipped a pair of headphones into their backpack. The employee blocks the exit and says, "You are not leaving until you empty that bag." The student says no. They try to walk around the employee. They want to leave, but then the employee steps in front of them and says, "If you leave, I'm going to call the police. I'm going to tell them that you stole." There's no handcuffs there. There's no locked room. They're blocking the exit and making it clear the student couldn't leave. So let's think about it in terms of the elements. Was there intentional restraint here? Was there this intent to confine? Yeah, because the employee physically blocked the exit. That is restraint. Was it unlawful? Well, this is a little bit where we'll have to get more evidence. Some states give merchants limited authority to detain suspected shoplifters, but only under certain conditions and for a reasonable time. It's going to depend on your state law. If the employee had no reasonable basis and no legal privilege, there could be false imprisonment there. So it's very fact specific. It does depend on the facts. And again, this is where it's very important to have the trusty paralegal along, who could potentially be doing the client interview. You're going to ask a lot of questions right here. And then you're going to research the state law regarding false imprisonment. When can a shopkeeper detain somebody? Here's some additional examples. Telling the victim that he or she leaves the premises, the victim will be beaten up. That's words. Words alone can create the tort of false imprisonment. Okay, so now we are moving on towards intentional infliction of emotional distress, also known as IIED, because we don't want to say that long word all the time. This requires extreme and outrageous conduct that intentionally or recklessly causes severe emotional distress. So, a lot of people, you've probably heard of this, mental distress, but the courts do set the bar high here for this. So being rude isn't enough, sadly. Can't sue someone for being rude. Being insensitive usually isn't enough, although fact specific, maybe there's some sort of a disability there or something where it could be. Being insensitive could rise to the level of IIED. But the conduct has to go beyond the bounds of decency. So, for example, imagine a supervisor falsely tells an employee as a joke that, oh my gosh, this is horrible, that their child has been seriously injured, just to watch their reaction. And interestingly, aren't there a lot of these reaction videos going around? So you have to be careful. This starts to look like outrageous conduct. This supervisor is being cruel. They've, obviously intentionally inflicted emotional distress. Ordinary workplace conflict, is that gonna rise to the level of IIED? Probably not. So courts will ask whether, the conduct would be considered outrageous by a reasonable person. So in all these cases, you are going to be using this reasonable person standard. What would they think? So it would be if it shocks the conscience of a reasonable person with normal emotional sensibilities. And then we've got some further, more complex definitions for you to take a look at too. Defamation. This is a tort that includes both libel and slander. This one is thrown around a lot. Libel is when there is a written communication of false and disparaging statements about an individual to third parties. Slander is oral communication of false and disparaging statements about an individual to third parties. So the key is here that false and disparaging. If the statement is true, there's no defamation case. It's true. The key is that the statement has to be false. So let us look at malicious prosecution. I actually knew of somebody that I don't know what this is called, but they were addicted to suing people. They had so many lawsuits in play. And of course, they gravitated to me. I was just a parent. This was a fellow parent in my students' class. They gravitated to me because they wanted to tell me about all their lawsuits. I found out later, too, that their parents had done that same thing. That's how they grew up. So some of these that obviously she told me about sounded a little bit, well, it wasn't exactly malicious prosecution, but it was filing lawsuits to harass people. So malicious prosecution occurs when someone brings or continues a criminal charge without probable cause, acts with malice, and the case ends in favor of the accused. So the accused wins. It's like you brought this criminal charge just to harass me. If somebody knowingly files a police report just to get back at a neighbor and the case is dismissed, then that neighbor, you can sue your neighbor who brought that false charge against you. You can sue him civilly. As you can see, there's a variety of intentional torts. Now we're going to briefly touch on property-based intentional torts. So trespass to land is one of the most common ones. This occurs when someone intentionally, remember that element of intent, enters another's real property without permission. You don't even need damage. Entry is enough. And trespass law presumes the injury happened simply because the tortfeasor interfered with the landowner's use of their realty. You went on their property, that causes an injury. Trespass to land, this is an interesting little caveat. It is not limited to the surface, but it can occur above and below grade. So property owner owns from center of the earth to the heavens, which is, kind of an interesting way of putting it. There are, of course, modern exceptions for aircraft. Toxic torts. These have definitely been in the news quite often. They involve toxic chemicals. When toxic chemicals sort of put on other people's land. But it's a huge area of tort law. There are lawyers that actually specialize in toxic torts. The underlying theories behind toxic torts are like trespass to land, negligence, so that's not an intentional tort, but a variety. So there is that intentional tort potential here to help injured people recover when they've been the victims of a toxic tort. So this intentional tort of trespass to liability is one of the routes that they can take. And frankly, if you've been the victim of a toxic tort, you're going to want to assert any possible tort that you can. The elements of toxic trespass would be the same as trespass to land. If trespass to chattel. So this involves personal property. What about you've borrowed somebody's laptop and you return it damaged? That could possibly be trespass to chattels. Keeping it and claiming it for your own, That's a little bit more like the tort of conversion. So this would have to do with personal property. And here are the elements. Whether or not the tortfeasor uses the chattel, that's not a required element. It's just there's been an unauthorized possession or interference with another's chattel, and the intent, again, it's an intentional tort, to dispossess or interfere with the owner's use of the personal property. This is a couple extreme examples: filling your hot tub using your neighbor's garden hose without the neighbor's consent, or urinating in his hot tub. Those would be examples. Conversion. So we mentioned this already. This is when the tortfeasor deprives the owner of possession and they put the property to their own use. So it's broader than trespass to chattel. And then we've got the elements on this slide. If this was a crime, it would probably be like the crime of theft or larceny, and the tortfeasor is required to put the chattel to their own use. I don't have a slide for this, but there is also the tort of nuisance. So nuisance would be, and actually, let me go. Nuisance would be, when you've got a neighbor, and you see it now all the time in the neighborhood groups, but you've got a neighbor blasting music every night at 2 a.m. Someone, you've always seen someone put it on Facebook. Someone is playing loud music, and then half the comments are, what's the address? I want to come too. I want to join in the party. And then the other half is like, my dog is sensitive to those sounds. I have a baby trying to sleep. It's disturbing me. I work from home. So yes, there are valid concerns with that. In many cases, people would call the police. A lot of times police are too busy. They don't come out. You could sue for nuisance under tort law. That being said, you don't have a civil tort claim if they've played music loud one night. This would, for it to be a nuisance, you've got to have this lengthy pattern of essentially your neighbors not allowing you to use your property in the way that you want to. So again, this discussion goes with the discussion board, the unit that unit 2 in Introduction to Torts, but this information is also practical for real life. We see torts arise in workplaces, stores, neighborhoods, social media interactions, driving down, well, I don't know, driving down the street. No, that's probably negligence. But, if somebody's using their car as a way to, harm you, it could be assault, it could be battery. But again, when you are trying to think about, is this an intentional tort, you'll look at, was the act intentional? That is really kind of like, what your inquiry is going to be. Was there harmful or offensive contact? Was there reasonable apprehension? Was the restraint lawful? Was the conduct truly outrageous? Some of the questions that we've looked at when looking at the specific tort. So, anytime somebody comes into the office, if you're a paralegal, if you're a lawyer and you're doing an interview, you are breaking down what they tell you, what happened, and you're sort of translating it into the elements of these intentional torts. And you're trying to decide, do we have enough evidence to support these elements? So thank you, everybody. It was, again, very nice to bring this discussion of intentional torts to you. And again, don't forget that distinction. A lot of intentional torts sound like crimes. They may well be crimes, but they can also be torts. And, if the tortfeasor has deep pockets, meaning lots of money, or some sort of insurance policy that covers their behavior, that's when you also want to file that civil case. Thank you, everybody. Bye.